Conservatorship Explained. This video is for informational and educational use only and is not legal advice. A California conservatorship is a judicially created relationship where an adult has been given the legal authority and responsibility to care for another adult. Generally, conservatorships can be three basic types: conservatorship of a person, conservatorship of an estate, or the conservatorship of the person and estate. The process begins when a proposed conservator petitions the court to become the conservator of a person. At this time, the proposed conservator will decide whether to seek appointment over the person, the estate, or both. Most conservatorship proceedings start when the person is incapacitated to the point that he or she cannot manage their own affairs. The person who is the caretaker is the decided conservator, and the person being taken care of is the conservatee. Why not use a power of attorney? While a valid power of attorney document can authorize the power of attorney holder to accomplish certain tasks of the conservator, a power of attorney cannot prevent the ill person from contracting, conveying property, or marrying. In such a situation, the California Probate Code provides that conservatorship may be established, and the conservator may ask the court to set aside any contract entered into by the ill conservatee. The advantage of the conservatorship is that it can safeguard against fraud against the ill person. A conservatorship can strip the conservatee of their legal right to perform many tasks. The conservatorship proceeding begins with a petition filed with the court, followed by an investigation by a court investigator and a court hearing. A conservator of the estate is required to provide periodic accountings that give details of the conservatee's property belongings, income, and expenses, showing exactly the status of all accounts maintained by the conservatee. In the event that several persons file competing petitions for the conservatorship, requesting that each becomes the conservator, the court shall decide who becomes the conservator. A conservatorship must continue until the court orders the conservator relieved from his or her duties. This can happen if the conservatee dies, if the estate is up, if the conservatee regains his or her capacity, or if the conservator becomes unable or unwilling to act. Candidates for a conservatorship can be, but not limited to, those who suffer from Alzheimer's disease, stroke, head injuries, Parkinson's, and other debilitating conditions. Conservatorships are not an easy decision and should not be entered into lightly. However, sometimes protecting a loved one from themselves is the best way to show them that you care. If you think you or a loved one may need a conservatorship, please give us a call at 951-226-5294 or visit our office at 27851 Bradley Road, Suite 145, Menifee, California, 92586. We will be happy to help.